All right, welcome. So I can't see. How many people do we have on right now? 37. We've got about 65 people that signed up tonight. Uh, we've got people that are current clients of WSR. We got people who are not. So we've got a good mix there. So we'll see how this goes, and we'll definitely, hopefully, get some good information to you that'll at least enlighten you, if not change the way that you do your property management or your landlord business. Um, First off, I am Richard Gibson. I am the Director of Residential Property Management here at WSR Real Estate. So I manage all the goings on for the single family homes and multifamily residential property management. We got a good sized staff. We've got Jeffrey Wolfslager, who's actually here in the room with me tonight. He's our broker. Eric Ekstrom is also one of the owners of the office. Rebecca Nelson's here in the room with me, who will be working on in the chat. Anna Halabnica, who is one of our agents. Alfred, Cordell, Sarah, Jenny, they're all agents and super important. Each one of them is in the front line and taking care of business for each and every one of you. However, the most important people are in the back office. You can see we got all these really nice pictures for our agents, and then we have the people in the back office that are like shy and they don't want anything to do with pictures. So I had to go around and get some candid pictures. But these people are the most important. From Connie with our reception, and Kina, our office manager, and Joni and Alex back in accounting. Super important people that couldn't, none of this could be done without them. So I'm grateful for the things that they do and taking care of our office. All right, so how you guys feeling tonight? What brings you out tonight? Let's start with getting you into the chat. So open up the chat. Let's get in some chat and get familiar with the chat real quick. Let me see if I can do the same. Where is my? There's my chat. Excellent. So, what brings you out? Are you concerned about the legal environment that we find ourselves in? Are you stressed out, intimidated, anxious? What brings you out tonight? We certainly have a lot of good information to share, and in today's political environment, we've got lots of crazy going on. But hopefully, by the end of our presentation, you'll at least have some good information and see where we go from there. Ultimately, for those who are WSR clients, we got you covered. This is our job. This is what we do. This is my a big part of my job is to make sure that each one of our agents are taking care of business for you. But real quick, let's get some more activity in the chat. For those who are current clients of WSR, will you just throw in there, who's your property manager? Throw just the first name in there real quick. Who's your property manager here at WSR? All right. So yeah, Alfred and myself, I've got several on here. Welcome, Cordell, Eric, Jenny. Excellent. Welcome, Anna. Yeah, Cordell. Yep, it looks like just about every one of our agents has somebody on. Excellent. I will do my best to help out with any questions that we have tonight. Ultimately, after tonight, of course, go directly to your agent. They should be able to answer any questions that you might have that we're not able to answer tonight. Perfect. For those who are not current WSR clients, Do you self-manage or do you have a property manager? What brings you out tonight? Are you looking for support in your self-management? Are you looking for further light and knowledge so you can understand where your property managers are at? Let us know. Are you self-managing or do you have a property management? Excellent. Let's move on. First off, a quick disclaimer. I am not a lawyer. I am not a lawyer. I'm if you hear something tonight that makes you think, well, he doesn't know what he's talking about, that's a good possibility. Consult a lawyer. If you hear something tonight, oh, that's a great idea. Let's do it. Awesome. Consult a lawyer. I am not a lawyer. So definitely, I am not a lawyer. Consult a lawyer if you have any questions. Perfect. So we got 12 laws that I'm going to go over real quick. The first three that I'm going to go over are old. Most of them date back 2 of them to 2019, one of them 2023. But if you don't have this base, you're not going to be able to move forward. These laws, in my mind, are kind of the beginning of where our current environment started. Obviously, it goes further back than this, but this is kind of where the state of California has taken over and really affected our environment, our property management environment. All right, there's a QR code. What was that QR code for? Oh, yes. The QR code there on the screen is a link to a page at the California Association of Realtors that basically is this packet of information that I'll be going off of quite a bit. If you guys will throw in the chat real quick, that link to this information. Yeah, the chart, the California Association of Realtors new laws chart. If you'll throw that in. So there's a link there in the chat as well as the QR code on the screen. But so we've got those three older laws that we're going to go over. Then there's 6 laws that I'm going to go over pretty quick. They won't apply to everybody, but you need to know about them. And if they do apply to you, then you can do some further research, reach out to us, and we can get some more information for you. And then the final 3 will be a little bit more in depth, a little bit more detailed, because they definitely apply to everyone. All right, so let's get started. AB 1482, the Tenant Protection Act of 2019, also known as the RCJC. This is a super important law that kind of started the whole statewide regulation of rents and evictions and capping all of that. Prior to this, certainly different cities have had their rent caps and eviction laws, but this is where it kind of started at the state level. So what does AB 1482 talk about? AB 1482 limits rent increases to Consumer Price Index, CPI plus 5% with a max at 10%. So ultimately, we can only raise the rent at maximum 10%. So which CPI? Which CPI, what month? Big questions that are not easily answered just on a quick Zoom. But yeah, it has to do with, in the law, it talks about which month and which CPI. Part of the problem is the CPI that it requires is April, but they don't even do an April CPI for Riverside. So the more questions than are answered in that. We have consulted with our lawyers and we do what we do, but definitely will need to consult with lawyers to figure out what to do in that case. Any idea what our maximum rent increase is right now for Riverside? Any ideas? Let's throw in the chat real quick. What do you think? What do you think is our maximum? If CPI plus 5% is our maximum, capped out at 10%, what do you think? Any ideas? In the chat, 5%. So 9.2. All right, you're cheating, Rebecca. 9.2. You better know. You're pretty darn close, but not quite. Mimi's at 10%. Close. The actual maximum for Riverside right now is 9.3%. So Rebecca was pretty darn close. Yeah, so our CPI last year was 4.3. So plus 5, that's a max increase of 9.3. All right, so that's kind of the parameters that we're working within, that we have to stay within. The other half of the AB 1482 is the evictions, at fault versus no fault, and relocation assistance. There are specific at fault, meaning the tenant is at fault for being evicted. Actually, before I go into that real quick, what does that word eviction even mean? In my mind, eviction means that we're going on to court, right? We're kicking them out. We're going to court. We filed court proceedings. That is an eviction. Actually, that's not an eviction. That's an unlawful detainer. Eviction is any time that we are talking about asking a tenant to move out. So that could be for good reasons, where we're asking them to move out because we want to sell the house, we want to do whatever, something different, or they're not paying the rent. It's all considered evictions, right? So we've got at fault. At fault is that they've done something wrong. They aren't paying the rent. They are in breach of a material term in the lease. They are committing a nuisance. They're committing waste. And these nuisance and waste are specific legal terms. To me, a nuisance is they're making too much noise or their dog barks or something. That isn't part of the legal term of a nuisance. So these words mean things. The tenant refusal to sign a new lease extension under similar terms, a few other things that they are doing or not doing that can cause an eviction. If we're evicting them under that scenario, not a problem. We can evict them and get them out through the normal court process. However, now in the past, before this law went into effect, we could ask somebody to move out for any reason. We did not have to have a reason to ask them to move out. We could ask them to move out because they're ugly and we don't like them anymore, but not anymore. There's a short list of no fault reasons that we can ask a tenant to move out. One of which, owner intends to occupy the property. So if you or a particular group of relatives stated in the law want to move into the property, we can ask them to move. We can, if the property is being taken off of the rental market, that would be like if we were going to sell it or something along those lines. If a government agency declares the property not habitable and they have to get out, then they can get out, but it is at a no fault of theirs. And intent to demolish or substantially remodel the property. And there's significant restrictions on what that means. So we do have some ways that we can get them out that's no fault. But if it's a no fault eviction, then we've got some more hoops to jump through. And the big one is that we've got to give them 1 month's free rent, or actually cash equal to 1 month's rent within 15 days of giving them that notice. So we've got some very specific parameters that we have to work within, unlike prior to 2020 when this went into effect, how we can get somebody out of a property. So that's 1482, AB 1482. Now, exceptions. There are some pretty important exemptions in this law. And bottom line, that comes down to what the house looks, or the property looks like, right? If the property is less than 15 years old, it's exempt. All of these exemptions are only exempt if you told the tenant at move-in that you were exempt. So if you didn't tell them, then you don't have the exemption. But if it's less than 15 years old, if it's an owner-occupied unit, like you're renting out a room or something like that, single-family residences are exempt for the most part. So single-family residences, that's most of what WSR does. So you're probably exempt. But the notice of exemption must be given before you're trying to get them out, right? So again, if WSR is handling your property, we're taking care of this. We're giving them those exemptions, notice of exemptions when they moved in. We gave them the notice of exemption back in 2020 if they are older than that, when this law went into effect. So you should be covered there if you are exempt. Excellent. So that's 1482, a very important groundwork for where we start with our laws tonight. All right, moving on to SB 329. That was went into effect also in 29. This is an important law because for some reason, there are a lot of landlords who are afraid of Section 8. Section 8, we can't be afraid of Section 8 anymore. We have to accept Section 8. We cannot discriminate based on source of income. As long as that source of income is legal, whether it comes from the housing authority as in like Section 8, or if it comes in from Social Security, unemployment, retirement, whatever, it's all legal income. It all must be considered. Section 8, we can't turn down for Section 8 anymore. We must accept Section 8 tenants. And kind of the crazy thing about Section 8 tenants, there are some other laws that bring in that we have to, if we always base income off of the rent, right? We require that somebody has 3 times the rent as their income, right? That's kind of normal, 2 to 3 times. If they're a Section 8 tenant, that number is based on their portion of the rent. So if they have $100 portion of the rent, that requirement is now at $300 for a $2,000 house or whatever, right? So just to know where we're at, we will probably at some point have to deal with this with every property. We're constantly getting phone calls. Hey, do you accept Section 8 on this property? Yes, by law, we have to. And quite honestly, I don't know why you wouldn't. I've had good luck. I've had excellent tenants. We still do our regular background checks. They still have to pay the rent on time. They still have to have, good rental history and stuff like that. So good credit, all of those things. We still do all of that on our Section 8 tenants. We just are guaranteed to get that money on time every month. So Section 8, we can't turn them down. Don't want to anyways. Perfect. All right. AB 12. Here's another excellent one. It went into effect in 2023. Actually, I think it went into effect 2024. It was passed in 2023. But this is about security deposits. We have new laws requiring security deposits. Our maximum security deposit that we can accept now is equal to 1 month's rent. The security deposit, we cannot get extra deposits for a pet. We can't get extra deposits because they have bad credit. We can't get extra deposits for all sorts of reasons that we used to require additional deposit. Deposit maximum 1 month's rent for any situation dealing with this. We used to be able to get up to 2 months rent for an unfurnished home. We used to get up to 3 times for a furnished home. Not anymore. Maximum at one time for those that are not exempt to this. Now, the exception on this one, there are exemptions. If you remember, the exception on AB 1482 was based on the property, right? It was all about the property. The property is a single family home. It's exempt. It doesn't matter how many you own. This one, it's based on the owner, almost solely on the owner. The owner is a natural person or a limited liability corporation in which all members are natural persons, and a trust is considered a natural person. So if your property is in a trust, then you're good on that. But you also, and it's a big and, you got to be a natural person, and you can own no more than 2 residential rental properties that collectively have no more than 4 dwelling units. So if I own 3 single-family homes, even though I'm a natural person, I no longer am exempt from the security deposit rules. If I own 2 properties, 1 single-family home, 1 duplex, you are exempt from the AB 12. So it's about the natural person and about how many properties you own, not about the specific property. But again, we're dealing with this. We've got our eyes on this. We know how to take care of this, but that's why we're not doing pet deposits. For many of our clients, we cannot do pet deposits any longer. But we'll probably talk a little bit more about this, pets and stuff in the Q&A when we get there. But definitely put your questions in the chat and we will get to them in our Q&A, or if something comes up pertinent right off the top, we'll get them to jump in and let us know. All right, excellent. So those were our 3 historical ones that we need to know about to kind of give us a base. Now I'm just going to run through 6 real quick just to let you know about them. Most of them, 5 of them don't apply to everybody. 1 is super important, but better be pretty clear real fast. AB 2533, unpermitted ADU amnesty. If you've got an ADU that you've added to the property that is unpermitted, New California law requires local cities to give a path to get those permitted. This is pretty important if you've got a converted garage or something like that. Again, not everybody's dealing with this, but just know that there is a path to getting those things permitted. AB 1815, this is the one that's more than good to know. It is required that we take care of this. This is fair housing. This is fair housing stuff. Prior to this, fair housing talked about, whatever the 8 protected classes are, race, religion, familial status, stuff like that. But this now adds traits to it. So if there is a trait that is stereotypically a particular race, we cannot discriminate based on that trait. Whether it's hairstyle is specifically talked about in the law, but there could be anything that is a particular trait that's kind of stereotypical of a particular race. But bottom line, why would we want to base our decision of who's going to live in a house based on some very meaningless trait, right? A hairstyle, a style of dress, a way they cook, whatever, has nothing to do with them taking care of the house or paying the rent, right? So anyways, moving on. SB 1051, lock changes. If a victim of abuse comes to us and says that they're afraid, they've had this abuse, and they want us to change the locks, we have to change the locks at the owner's expense. Previous to this law, it was not clear who had to pay for it, and we would be pushing it back onto the tenant. That would Makes sense to us. You're asking for it, you do it. But the law is very clear now that if we are changing the locks due to a possible abuse scenario, it is the owner's responsibility to pay for it. All right, moving on real quick. AB 2579, balcony inspections. All elevated elements at a property of 3+ units must be inspected this year and then inspected again with every 6 years. So what does that look like? In the picture on the screen, you can see like this walkway or the stairs, a balcony, anything that is elevated and is made out of wood, internally is made out of wood or supported by wood, must be inspected this year by the end of the year. So that's kind of what we're looking at there. So we're working on those. We have, in talking with our property managers, it sounds like we've got maybe half a dozen properties that need this. So not a big deal there, but we've got that covered. All right, AB 2347, unlawful detainer. Again, unlawful detainer, that's the actual eviction proceedings in court. They have now made it so that a tenant that is being evicted now has up to 10 days, not including weekends and holidays, to respond. So we're just a few extra days in their response time. Will slow down evictions a little bit, but what's a couple of days? All right, SB 611, no 3-day notice fees. This actually applies to any notice to vacate. So any notice that says quit or vacate or get out, whatever, how we're going to say it, any notice, we cannot charge a fee for service of that notice. All right, perfect. Moving on. Now here's let's take some time on a few of these new laws. AB 2747 requires that we offer tenant credit reporting, positive credit reporting for our tenants. That means that we report to a national credit reporting agency their good payment history. We are limited. We can't report, well, through this, we certainly can elsewhere, but through this, we cannot report bad credit history. But this is positive credit reporting. We've got our plan, and we'll talk about that here in just a second. It is the cost to do this. We can charge the tenant up to $10, but no more than the actual cost. So there's some cost recuperation, but a relatively small landlord might struggle figuring out how to do this. Exemptions. Now, this is where the exemption comes in. Small non-corporate landlords. The actual exemption reads something like this. Exemption exempts any landlord of a residential rental building that contains 15 or fewer dwelling units, unless that landlord owns more than one residential rental building and is either a real estate investment trust, a corporation, or a limited liability company with at least one member corporation. So in reality, this probably exempts 99.9% of you because you'd have to own a building greater than 15 units, so 16 or more units in that one building, or 2 single-family homes, 2 buildings, and be a corporation. So most of you guys are going to be exempt on this, but we have taken the stance here at WSR that we might as well get it to everybody. We are have a positive credit reporting process that all of our tenants can and do participate in, and we're taking care of this. So even if there is a question about your exemption situation, we've got that covered. We are good there. All right, moving on to AB 2801, deposit deductions. Oh, this is going to be a really fun one. Deposit deductions. We have to do 3 sets of pictures for each deposit deduction. I've got to be able to support a deposit deduction with a picture at move-in showing that the carpet was clean, or the carpet was brand new, or the light bulb was working, or whatever, the hole in the wall wasn't there. I got to have a picture showing that when they moved out, the problem, and I got to have a picture showing that it was actually repaired. So this is kind of crazy, but you can see on the screen there, those are 4 pictures of one of my move-ins recently. Every light bulb, I've got a picture of every light bulb. I've got a picture inside every cabinet. That house was about a 2,300 square foot house. I probably took over 200 pictures of that property. My smallest properties, I take 75 plus pictures, in a little 1-bedroom apartment, because you never know. You don't know what is going to be the problem when they move out, right? So you got to start. You got to take lots of pictures at the beginning, which all of my staff are doing. We've already been doing this. This really was not a big deal when this law came forward. And taking a picture, we were already taking pictures at move out. Again, documenting, well, this is what it looked like when you moved in. This is what it looks like now. And here's the receipt. That was our normal process for documenting, but now we actually have to give that to the tenant when we do their deposit deduction. And thirdly, we have to have a picture that it was actually repaired. And kind of the crazy thing is, we still only have 21 days to do all of this. From the day they turn in the keys to the day that we settle up with their deposit. That is what we've got. We've got 21 days to deal with all of this. Now, the words in the law talk about reasonably necessary. We've got to be able to handle these issues that are reasonably necessary to bring it back to the condition that it was in at move-in. To me, this kind of the big thing is carpet cleaning. There have been times that they didn't clean the carpet. It looks good, but they didn't clean it, so I charged them to clean the carpet. I don't think we can do that now, right? If it looks the way it did when they moved in, we may not be able to charge them just because they didn't do it. It's there, they agreed to do it, they didn't do it, so we charge them. On some things like that may not be reasonably necessary, just based on the way it was when it moved in versus the way it was when they moved out. But the only big change here for us at WSR is providing those last pictures and providing the pictures, all 3 pictures, with their deposit deduction at move out. All right, excellent. AB 2801 done. Deposit deductions, we are big time handling that. AB 2493, this is another huge change based on application fees. The law now says that we cannot charge application fees unless we can check a couple of boxes. Number 1, there has to be a unit available, or a unit available within a reasonable amount of time. If there's no unit available, we cannot accept an application fee, which, quite honestly, that's just the honest thing to do. We haven't been taking application fees outside of that situation anyways. But if somebody's making money off their application fees, that's no longer can be done. You cannot accept an application fee unless you are publishing or providing with the application your screening criteria and process. We have done that. We've gone through and we've got a huge list of things that check boxes that we want to see available. It links right at the top of our application online. And so they can see that. So we have fulfilled this. We have actually elevated our published screening criteria to give us some leeway, because obviously each one of you have, depending on the property, depending on the owner, depends on what we're looking for. So we have published our highest criteria, and then we can come down. Quite honestly, at this point, I don't think anybody's clicking on that. I don't think we're getting any lookers and readers on that, but huge long list of stuff that we are looking at, including credit and income and legal issues, convictions and stuff like that. Okay. One big thing in this law is that we have to, first one in line, first one to meet those criteria must be who we accept. We can't get 5 applications in, all 5 of them meet our criteria, and now I'm going to pick the best one out of those 5. We can't do that anymore. We've got to go step by step, one by one, get this one screened. If it meets our criteria, that is it. We do not get to play favorites anymore. So that's a big change. If we do not have our criteria published and we turn somebody down, we have to refund their application. It doesn't matter if their credit is 300 credit score or they have 5 evictions on their record. If we're not publishing or providing our criteria, then we have to refund the application fee. And this was a big thing, that big question that I don't have answered yet, and perhaps anybody who is currently using like the Zillow applications, if you know anything about this, I'd be more than happy to talk to you. I'd really like to know more. How are the Zillow applications handling this? I've seen on Zillow they provide like 2 or 3 criteria, but 3 criteria does not make for a good screening. So if you know how Zillow is handling this, I would really love to know. All right, perfect. So those are our laws. Looks like we've got some good questions in the chat. We'll get to those here in just a second. A real quick recap of our night. The laws are constantly changing. We really, as a property management company, as a landlord, really have to be on top of things. You just never know what's changing, when it's changing. Got to pay attention. Hopefully, you have a good property manager that you can rely on. You have an association that you can work with, whether that's the apartment association or something along those lines. There are definitely some good associations that can help you out. Here's a great little guide that I have referred several owners to. And if you guys will put the link in the chat to the California Tenants Guide. This is put out by the state of California that gives a really good overview and some good scenario type items that you can look at and get some idea of what what the laws are like. However, this is a tenant's guide, so it is definitely leans a little bit towards the tenant side, but I think it is a very good little guide that can give you some good ideas of how to deal with any problems with tenants. Again, QR code directly to that PDF on the screen for another second or two. There is the link there in the chat. All right, perfect. So all right, that gives you some quick overview of some great laws that we are dealing with. Hopefully tonight was worth your time. We'll get onto some chats, give you a quick overview. Hopefully you're feeling a little bit more confident. Hopefully you learned a little bit of something and give you a little bit of a base of how we are dealing here in California with the California statewide laws. Riverside, luckily, is still fairly conservative on their uh, you know, landlord tenant laws, and we are really pretty much only capped by our state laws. And most of those in the area are the same. We get into LA, and Long Beach actually is super strict on a lot of things. But definitely stuff that we need to know there. So hopefully you're feeling a little bit confident, feeling good, and are good to go. However, if you are a WSR client, definitely have more questions, definitely reach out to your property manager. If you do not know who your property manager is, reach out to me, let me know, and I can get you hooked up with them. Definitely ask your questions. If you are not a WSR client and still have some questions, we are good to go. You can definitely hop into click on the link in the chat and schedule an appointment directly with me, and we can chat some more about what we can do to help you and figure out where you need to go. If you do click on the link in the chat, I think they put it in. You guys put it in, right? Yeah. Might throw it in again. We've already got some more comments that have strung it up. You'll come to this screen right here, so you can actually schedule an appointment right into my schedule. It goes right into my calendar. And so we are good, and we will reach out to you. For new clients, if you schedule through that link, we'll get you $500 off any of our services, and see where we can help you out. All right, so let's get into some Q&A. You guys got any questions come to mind?
Got a few. Well, one that just came in and said, how do we handle the move-in pictures if the property has been under management for a long time already? Not sure we had that many pictures taken.
Well, luckily, this is a moving forward situation, right? We are not required to back up and manufacture pictures that we don't have. So this is a moving forward situation. Hopefully, with my property managers have done what I've been telling them to do for years and taken lots of pictures. We've got other ways of supporting that, but this is a moving forward situation. We do not have to manufacture pictures for a move-in prior to this law going into effect. What else?
How often does WSR come across Section 8 tenants?
Well, that depends on the property, I would have to say. I personally have a full gamut. I personally manage properties from a 33-unit complex out in Beaumont to stuff in Moreno Valley, Riverside, up to what our highest, probably most expensive property is somewhere in the neighborhood of $5,000 or $6,000, I think, on rent. Definitely in the lower end, we interact with Section 8 tenants on a regular basis. At the higher end, definitely don't. One of my favorite stories about Section 8. I had a tenant in a nice house in Murrieta. They were the nicest tenants that I ever had. They knew that this house was a gift. They could not afford this house, and they knew it. Every time I was there, I was like royalty. And that is typically more the way I see most Section 8 tenants, because we are still doing our screening. Highly recommend not being afraid of Section 8 tenants. Super good tenants if you're still doing your normal screening. All right, what else do we got in the chat?
So I know some of this was answered in the chat, but I'm curious as well. So they asked if we can say no pets altogether, and the difference between service animals versus emotional support animals. I know that service animals are protected. You can't say no to them, but what about emotional support animals?
Excellent question. Excellent question. All right. Yes, you can say no pets. Service animal versus emotional support animal. Same thing, bottom line, same thing. One performs an outward service, Perhaps they wake up a owner that has PTSD and they're having night terrors. Blind, obviously, a seeing eye dog, obviously is well trained and does his job. So that is a service animal, right? An emotional support animal can be anything from a dog, a cat, a pig, a miniature horse, but they're the same thing. They literally are the same thing in the eyes of the law. They do require, some have training, some don't, but they are the same thing in the eyes of the law. Yes, you can say no to pets. You cannot say no to service animals or emotional support animals. My experience 15 years ago. Well, actually, before I get there, this is the question that I asked for some different opinions on. Rebecca, what's your opinion on service or on pets? Do you recommend pets? Do you suggest no pets?
I go both ways.
How's that?
Pets can mess up a house, but so do people. And sometimes the reality is that you've got a lot of people with pets. And if you want to rent your place to a good tenant, sometimes they're going to come with a pet. So it really depends on the pet and the person for me.
Yeah. Yep. No, I totally agree on some ways, especially if there's no carpet, right? Well, they're probably not going to damage much. Carpet is kind of the big things that a pet's going to damage, right? So if there's no carpet, it's no question to me, right? Now, in my opinion, 15 years ago, I was zero pets. I was all no pets. No pets. I don't like pets. Pets are a problem. Pets make my allergies go up when I go in for my inspections, whatever. I just didn't want pets. However, as the years moved on, I found more and more tenants saying, oh, this is an emotional support animal. Well, now I have to allow the pet, right? I think it's a pet. They're saying it's an emotional support animal. Now I can't charge rent. I can't charge extra deposit if we're exempt and can charge extra deposit. I always now recommend allowing pets. It lets them be honest. I think most people want to be honest as long as it's not like some crazy fee that we're going to charge. They want to be honest. They want to be upfront with us, but we have to give them that path to be honest with us. And if they're honest with us, now we can charge a little bit extra rent. And if you're exempt from, what is it, AB 12, I think, whatever, the maximum security deposit law, we can charge a little bit more on the deposit to cover those potential issues. So I always recommend allowing pets now. Otherwise, you are leaving money on the table. But I totally get Rebecca's perspective. That's where I was, maybe even more stringent 15 years ago when I started. So I just have changed a little bit based on what I've been.
It's tricky too. Like you have a really small place and a guy that wants to bring 3 Rottweilers.
Yep.
That probably isn't going to fly.
Yep.
So it just depends.
Yeah, and the laws are very clear now that we cannot decline based on a certain breed, right? Like Rottweilers stereotypically are an aggressive breed, but we can't say no Rottweilers.
I didn't know that.
Yep.
Because insurance still does.
However,
I'm like,
now you may need to go to the insurance company and ask for a qualified exception. Yeah, because they're part of the housing provider area as well. So they are required to provide a qualified exemption as well. So I just seeing, can you just decline by size? Sure, you can still decline. You can still decline pets. You cannot decline service animals and emotional support animals. So if you start declining based on, certain criteria, then you're going to push them into saying that, well, it's an emotional support animal. Here's my piece of paper that I paid $10 on the internet for. See, it really is an emotional support animal. So I skate a thin line there, I'd rather get the money to protect you than, trying to protect the carpet that's going to get damaged anyways. I don't know. That's my thoughts on pets. Any other questions on pets? All right, perfect. What other questions we got in there?
So one person asked, what is WSR's current criteria, or is it a standard criteria mandated by the state government?
For applications?
Yes.
No, it is not standardized. We can still set our own criteria. Thank goodness, because they would bring it down to anybody and everybody. We have set our criteria. I do not have that in front of me. I think our published criteria is a 675 credit score, 3 times the rent income, no evictions. And then there are a bunch of other criteria in there. There's literally a list of 50 criteria or something like that. So that's kind of our published criteria. Again, we have taken that above and beyond. We will walk that back for many of our properties. There is no way I'm getting 675 on my little 1-bedroom apartment downtown Riverside. It's just not going to happen, right? So we can walk that back, but we can't increase above our published criteria.
So here's a tag along to that question a little bit. If you have one home to rent, you own one home, you're renting it out, are you required to accept the first tenants that reach the tenant criteria?
Yes, by law, we are required to accept the first applicant that reaches the criteria. Exactly. So again,
Set it high.
set it high.
Make sure you show it.
And you can walk it back. Set it low, you cannot, increase it, right? So set it high and you can bring it down. Hey, this is my criteria. I didn't get any applications to meet this criteria. I'm going to negotiate.
So another question relating to pets, and this also, again, when you're talking about not allowing pets, this gets pretty much squashed if they're emotional support or service.
Exactly.
But can you have limits on the size of the pet?
Yes. Yes. Yes.
Example, like under 30 pounds.
Yes. And in fact, our website, the way our website works, I think we can tag it that we accept cats and we accept dogs, or we accept small dogs. But again, every criteria that you make is going to push somebody out of being able to be honest and you being out of being able to collect a little extra rent each month. I typically collect an extra $25 to $50 per pet each month. So if that's one pet, say $25 a month, and they're there 2 years, you just gave up whatever that is, $800, if my math is right, over those 2 years. That $800 can do quite a bit of repairs that pet may have done. And again, if you're exempt from AB 12, then you can actually increase get a pet deposit as well. So you got an extra $300 in a pet deposit. You're now, what did I say, $1,100, if my math is right off the cuff, right? $1,100 can solve a lot of pet problems.
So one other on WSR, how often does WSR do inspections on the properties that we manage?
WSR, it does quarterly drive-by inspections. So I'm driving by the property, waving to the tenant as I drive by. I can't tell you how many times I get a text. Was that you driving by? Yep, just taking a look. But yeah, so I'll drive by the property.
And what are you looking for when you drive?
Thank you. Yep. What am I looking for? I'm looking for any red flags. Is the lawn being taken care of? Is the window broken? Is a myriad of different things being taken care of? Do they have a car on blocks, in the driveway or parked on the lawn? That's been a big one this week. I don't know why I've got 2 that have broken sprinklers because of cars on the lawn. What the heck? I don't know. But yes, so those are the things that we're looking for. If I get any red flags on that drive-by, I will schedule an in-person interior inspection. No red flags, then I move on to the next quarter. At least once a year, I'm inside the property. California law does limit what I can look at, sort of. California law limits that we check smoke detectors and check water heater. But surprise, surprise, that gets me in almost every room, right? So I really am, although that's what I'm saying I'm there for. I really am walking in and I'm looking in every bedroom. I'm looking in the main area. I'm looking in the garage because that's probably where the water heater is. 99% of the time, if I ask, they'll let me look under the sink. Hey, you got any water leaks? Let me look under the sink. If I ask, they'll let me look at those things as well. Rarely have a problem. But yeah, so at least annually I'm inside, and quarterly we're driving by and taking a look and making sure everything's good. What else?
I had a question earlier. Are tenants allowed to sublease a room within the rental property for a single family home?
That is up to the way the contract's written. We write all of ours. No, they are not, they cannot sublet. They can't sublet. They can't short-term rent. But that's just a checkbox in the lease. So that's really up to the landlord. But our normal process here at WSR is no subletting. What else?
Well, you can probably address this out loud. A lot of these questions are being answered in the chat too, just, in case you want to look. They asked another one kind of goes with that. How often do you check the home condition? And that kind of goes with what you were saying.
Yep, those are the inspections. Exactly.
Can you charge a cleaning fee in addition to the security deposit?
No. Any monies paid upfront other than rent is considered security deposit. So we are limited by AB 12 to what we can charge. You cannot charge an automatic cleaning fee, whether it's within the deposit parameters or not. You cannot charge an automatic fee. California law requires that we allow the tenant to do everything that they can to get their full deposit back. So we must, again, by California law, we must offer a pre-move inspection where we go in and say, all right, you got to do that, you got to do that, you got to do that to get your deposit back. And we have to allow them that opportunity to do that. So no automatic fees, no cleaning fees, no end of lease fees of any sort automatically.
It's good to know these laws. We cannot guarantee that all people are following them because I know full well that there are places.
Oh, absolutely.
That will. So,
yep.
But we make sure that you guys aren't at risk.
Yeah, and right now that we are under major scrutiny in Southern California with the fires, with price gouging, there are real estate agents going to jail. We need to be on top of these and make sure that we are taking care of you, protecting you. We got to protect WSR. If we're going to jail, you're probably going to jail with us. So let's not go there. What else?
Can a tenant deny landlord yearly inspection related to COVID issues?
I would have to say not anymore. We're outside of COVID. There were a lot of COVID related protections. But yeah, I'm going to say that, yeah, there's probably no protections there. They can, in theory, not allow us to enter the property at any time. What they are renting from us is the peaceable use of the property. So that does create some interesting scenarios. WSR has been taken to court and said that we entered a property illegally for one of these inspections. We did prevail in court because when we go to the front door, our first question is, may I come in for an inspection? If they let us enter, then we're fully legal. We are taking care of business. We can go in. If they say no, we're gonna leave. We're not gonna cause any problems, and we're gonna try and negotiate and figure out what we can do. And then in communication with our owners, we'll figure out maybe it's time to let them go. We'll find a way to get them out. We'll, go somewhere else for another tenant. But yes, they can say no, but COVID issues, I don't think we have any. I have had several say, hey, we've got COVID right now. All right, let's reschedule for 2-3 weeks down the road. If they really have some problem in the house that they don't want me to see and they solve it in 3 weeks, all good. I'm good. You're all right. So no, I don't have a problem. We haven't had any issues with that. What else?
So there was some concern at the beginning about unknown tax implications with new laws. Do any of these laws have any effect on tax at all? And do we know?
I am not a tax guy. That might be a question for your tax consultant. However, I don't know of anything. I don't know of anything that would be concerning to taxes. No.
Anything else show up you guys saw?
One just came in. Are there laws that differentiate between renting a single family home versus per room?
Yes, there are a couple. That the exemptions were greater for somebody for a room rent. AB 1482, a couple of others. Unfortunately, WSR does not do room rents, so I'm not real familiar on that, right? So it's a little bit outside of my purview. But yes, if you are renting rooms, some of these exemptions are different, including like a protected class, right? I cannot discriminate in a 1-bedroom apartment against a guy or a girl, right? Doesn't matter. However, if I am a woman renting out one of my bedrooms, my understanding is that you could require a female, right? You're living in the same house. I can require a female. Again, I don't do room rents, so verify that with your legal. But yes, there are exemptions or different scenarios where room rents have more leeway than we do here at WSR.
So we have a question on ADUs that you may or may not be able to answer. I know Eric's been doing a bunch of that too, but in case somebody else has that question, he's been answering. Do you know if you have ADUs that aren't permitted, how invasive will they get to get it permitted, i.e. cutting open drywall, making tenants move out for work to be done, etc.?
We don't have that information as far as I know. The law just mandated to cities that they create a path to getting these ADUs approved or permitted, right? The law did not specify what that path looked like, but the point is to get them permitted, not to get them tore apart, right? The point is to increase housing availability, not to get people to follow the law. So I think that you probably would be pretty good, looking into that and squaring away with that. But unfortunately, that I do not know. That would be up to every city. Every city would have to figure that out. What else? Anything else?
Currently.
All right. Well, let's throw that link back in. If you have any other questions, please reach out to your WSR property manager. If you are not a WSR client, click on the link that they're putting in the chat right now, and you are good to schedule an appointment directly with me, and I will do my best to answer any questions that you might have. Perfect. Anything else? Anything else coming up in the chat? Going once, going twice. Also, that link will be, all of you are going to get these links. If I don't get all of our current clients out of this texting system, you're going to get some of these links emailed to you and texted to you. But again, reach out directly to your property manager, please, and they will take care of you. The rest of you, if you do not have a WSR property manager, I will be more than happy to work that out with you. All right, perfect. Thank you. Thank you. Have a good night. We will talk soon and see you next time.